Hi, I'm former bar grader and law professor Bijlani. And are you just tired of hearing people give you advice on what to do for the bar exam? Or are you just tired? I help bar takers pass the bar exam without the endless substantive law lectures by empowering them with specific methods on how to write purposefully for the bar graders and to be able to answer MBE questions with great accuracy. I'm sure you've heard a lot of advice and are confused and lost as to whose advice to heed, be it a former professor, a tutor, a practitioner, someone from a major bar company, your friends. There's a lot of conflicting information out there, and a lot of it just simply isn't based in fact. Being a former bar grader, I can tell you first of all that the bar exam is not insurmountable. You can do this. However, your journey begins with a true understanding of what the bar is all about. It's not all substantive law. In fact, that's only about a third of the equation. Now, I'm not here to talk to you about the validity of the bar exam, whether it's a sham, whether it's the best thing. It's neither one nor the other. I am here to tell you, from the perspective of a former bar grader, about what the bar exam truly entails in its current form. And hopefully this will inform how you prepare for the bar exam. The way that I see it is that there are three fundamental lawyering skills at play. The first one is law knowledge. That's how well you deal with the rules. The second is law application, how well you deal with the facts of a case. And then the third is law expression, how well you put it all together. These three major skill sets come together in one way or another, whether we're talking about the written portion of the bar, the essay or the PT, or whether we're talking about the MBE, believe it or not. Yes, even law expression is something that comes into play on the MBE. And so I will talk to you about each one of these skills one by one. The first set of skills is law knowledge. Law knowledge, again, is how well you deal with the rules, the R in IRAC. Law knowledge is not about whether you can regurgitate all the rules that are delivered to you by some person behind a lectern who's been talking for hours on end. Nor is it about your ability to regurgitate all the rules that you see in a book that is full of 70-page outlines per subject. It's about your ability to demonstrate true comprehension of the rules. And how does one demonstrate true rule comprehension, their understanding of the rules? Well, by first identifying all the general rules of the doctrine, and then identifying all those rule elaborations that are relevant to the discussion, and not dumping everything that you know about the doctrine. It's also about your ability to deconstruct the rules in terms of their individual elements as completely as you can, such that later on in your analyses, you can unearth each one distinctly and judiciously. And it's also about your ability to articulate the rules in a lawyerly way. And by articulation, I don't mean can you wax eloquent. I don't even mean can you speak English. This is about whether you can just articulate the rules in terms of their buzzwords. Buzzwords. And why are buzzwords so important? Well, as you know, the bar grader is spending only about 2 to 4 minutes per essay answer, and only about 4 to 5 minutes on each of the PT answers. And in that short amount of time, they're looking for words to pop off the page. They're looking for keywords. They're looking for buzzwords, those terms of art. And that's all you really need to demonstrate as best as you can on the essays, PT, and believe it or not, how you want to think about it on the MBE. At Esquired, I provide you with all the general rules of the doctrine. I also provide you with all those rule elaborations you're going to need to attack any question that comes your way. You will also see that I deconstruct all the rules for you into their individual elements in the way that the bar graders want to see, in terms of those very buzzwords that I was looking for as a bar grader when I graded the California bar exam. In short, this will eliminate your need to enroll in or re-enroll in, if you're a repeater, in a major bar review course that gives you endless hours of substantive law and not much else. Because what I do is to comprehensively, logically give you substantive law outlines in each subject. Comprehensive in the sense that it's not too much, not too little in terms of what you need to do to get the job done right on the bar exam. It's also logically constructed in the sense that I pay very close attention to those hierarchical relationships between the rules, so that you know what rule actually belongs where, and it modifies another rule. The substantive law that I give you is on average only about 17 pages long per subject. And believe it or not, that's all the bar law that you're going to need for both essays and MBEs. Finally, as you know, the keywords are very important. So all the substantive law that I give you is framed in terms of those buzzwords that the bar graders are looking for. The next set of skills is law application, how well you work with the facts of the case. That's the I and the A in IRAC. In terms of the I, issues, you need to spot all the major and minor issues triggered by a specific fact pattern. And I mean all of them, because if you don't spot all the issues, big and small, you're not going to get a good score. And why is there such a premium on issue spotting on the bar exam? Well, think about this. This is a licensing exam. And if you were a practicing lawyer, you would want to see all the problems of your client's case. Because after all, if you don't see the problem, you're not going to be able to resolve the problem for your client one way or the other. So it's important for you to spot all the issues on the exam. Issue spotting is the most fundamental of all the fundamental lawyering skills. It's where you're asking yourself, what is the problem? And if you don't see a particular problem, you don't see a particular issue, you're not going to solve that problem through rule analysis and come to a conclusion. So issue spotting is the most important skill of all. As far as issues go, it's also about prioritizing those issues. No issues are necessarily created equally in terms of how much treatment you need to give them. And why is that? Because a certain fact pattern can focus more on a particular issue than another, which means that there are going to be more points allocated to one certain issue over another. Therefore, because of the strict time constraints, you need to know where your bang for your buck is going to be. Which are those issues that I need to spend a lot more time with, massage out, versus which are those issues that are slam dunks, things that I could get into really quickly and get out of very quickly. Your ability to do that will help you maximize your points based on the hour you have on the essay and 90 minutes you have on the PT. In terms of analysis, analysis does not mean that once you spot an issue, you then put the rule that you just merely list the facts that speak to that issue and that rule. No, any trained monkey can do that, but it takes a lawyer to take each and every one of those deconstructed elements and address how the facts, the specific facts, have satisfied each and every one of those required elements or not. And so that is the sign of a true lawyer, the ability to take the rules and to move forward with them in terms of their applicability to the situation in front of you. What makes the bar exam really difficult is not only just working with the facts that are spoken to you, that are there in front of you in black ink, but to work with facts that are unspoken as well. Read between the lines. Think of the surrounding circumstances and make reasonable inferences to the unspoken facts as well. This is quite a difficult skill to do, and presumably the bar exam tests on a skill that you would have developed over a long period of time through law school. On the PT, there are a couple of additional components in terms of analysis that are more acutely tested there than on essays or MBEs. And that is, number one, it's your ability to pay very close attention to those unique instructions that they give you in that preliminary document called the task memo. For example, if they say to you, in writing this memo of points and authorities, Be sure to attack the credibility of opposing counsel's witness. Well, you better believe that in your analysis somewhere, the bar grader is going to be looking for a credibility attack. It's also about your ability to analogize and distinguish the facts of your case to those facts that are presented in the cases that are in the library. And why is that? This exam is about your ability to practice law in a common law jurisdiction. And in a common law jurisdiction, in most areas of law, what is it that we do? We take case precedents that we have found and make such analogies and distinctions to bolster the quality of our arguments, to bolster the quality of our analyses. So that is pretty much the only place on the bar exam where the state bar is actually looking for your ability to do that, regardless of what jurisdiction you're in. So as you can see, the skill of law application takes copious amounts of practice. And at Esquired, you better believe that you're going to be working hard to develop those skills through copious amounts of practice. The final set of skills tested on the bar exam is law expression, how well you organize your answer, the eye-racking itself. Now, eye-racking we typically associate with writing, essays, and PTs. However, innately, we are eye-racking as we go through an MBE problem, believe it or not. Let's talk about that for a moment. What does organization mean? Well, on the micro level, you know that eye-racking is logical legal reasoning. You take an issue, what is the legal problem? You then have the rule statements, which are showing you what tools society gives us to solve a particular problem, and then the analysis, which is an application of those tools that society gives us to a unique set of facts, and then the conclusion is how the court would resolve the problem in relation to those rules and the facts in this particular problem that we have at bar in front of us. On the macro level, organization means how well you're able to establish relationships among the issues. Let's take a quick and easy example, negligence. Why do we organize the issues under the doctrine of negligence as duty, then breach, then causation, then damages, rather than duty, causation, breach, and damages? Because duty and breach go hand in hand. There's a logical relationship there. Duty establishes in part the standard of care. Breach establishes how the defendant did or did not rise to that level of care. It gets a lot trickier when you're talking about more complex doctrines like First Amendment law. Free speech, when you're dealing with facial challenges, substantive challenges, lesser types of protected speech, each with its own standard review. How are you to organize all that? Your proper organization demonstrates your fluency, your parlance with the doctrine, thereby warranting the bar card. So as you can see, the skill of law expression too, like the skill of law application, requires copious amounts of practice to develop. And so, of course, at Esquired, we practice to develop not only how well we're dealing with the facts, but how we're going to format our answer, the organization on both the macro and the micro level. And there you have it. From a former bar grader, these are all the fundamental lawyering skills that the state bar is looking for. And none of this should come as something new or as a big surprise to you. You've heard of these skills in one way or another from your professors in law school, maybe someone else. But the bottom line is, you want to develop these skills that you first ventured to develop in law school. As you can tell, the practice of law consists of an arc of learning that includes the bar exam. The arc begins with first year of law school, where you are oriented to each of these fundamental lawyering skills in your doctrinal classes as well as in legal writing. And then into your second year, you continue that and ramp it up, possibly with moot court. And then in your third year, you come to the place where you've applied it enough to a variety of testable subjects on the bar exam, as well as subjects that are not tested on the bar exam. And then come to the bar exam and include what you know in terms of law knowledge, law application, law expression, and demonstrate the skills that you have to the so-called minimum competence standard, and then you carry it forward in your legal practice, in how you do things. And that's the beauty of what Esquired does. It doesn't really stop with bar tutoring or bar preparation. What you have after going through a program with Esquired is a lifelong set of skills that will carry forward through your law practice. Believe it or not, former students of mine call me sometimes and email me and let me know how they're doing in law practice. And they say, Jay, that whole thing that we did together in bar review, it's totally applicable to what we do in law practice. My judge loved the quality of my law application, my analysis, the kind of arguments that I was making on behalf of my client, and my client loved it too. The bar exam is meant to test on all these fundamental lawyering skills. Now, it does have its problems, and they are working through and adapting and morphing the bar exam to make it more realistic of what bar practice is like. However, at this point, get inside of the grader's head. Get inside of the MBE creator's head. Know exactly what skill is being tested at any given time, and then shine. Just reflect what you know from all that you have learned and apply tried and true methods that really will get you to where you need to be. So don't just go back to what you hear online with the chatter that you hear from people who have not passed the bar exam, people who have passed the bar exam but don't really know what they're talking about. Just take it from me, a former bar grader and professor, to help you get where you need to be one step at a time. If you got something out of this video, please hit like and subscribe to my channel, as I will be posting more videos as time goes on. In the meantime, please check out my website at esquiredbar.com for more information about the programming that I offer to my students in preparation for the California bar exam, as well as for MBE preparation, regardless of the jurisdiction. Take care, and may you defeat this beast. Happy studying.